Hello, today has been 19 months since my two children, Alec and Lydia, went to be with Jesus in heaven. I had the opportunity a few days ago to read this speech in front of the Arizona Judicial Committee. I, however, did not get the opportunity to read the full speech in my words via my voice because I only was given 3 minutes. So for that reason, I am going to be reading it in its entirety. I do thank every single person who was there with me during the AJC meeting and stood up and spoke on my behalf as we were able to get the speech fully read. However, I want to make sure that I have the opportunity to read this speech in my own voice. Thank you so much for your continued support, and I would greatly appreciate it if you would share this video and make sure that it goes viral, and even if it could get to President Trump to let him know the audacity and the things that happen in Arizona Family Court that need to be changed. Good morning, Chief Justice and members of the council. My name is Hope Hooten. I am the mother of Alec and Lydia Mater. They were two beautiful and joyful children who lost their lives because the Arizona Family Court system failed to protect them. I am here not only as a grieving mother, but as a citizen demanding accountability and reform so that no other child is placed in the danger my children were placed in. I am asking this body to confront a system failure, not a personal tragedy. In October 2023, I filed for divorce and was granted an order of protection after documented physical, sexual, and emotional abuse. I requested that my children be placed on the order of protection, but I was told that my only option to protect them was to go through the family courts. Just days later, their father experienced a severe psychiatric crisis. He violated the order of protection by coming to my home and attempting to break inside. He then removed the children from school without my knowledge. When I learned my children had been removed from school, I called the police. I was told that nothing could be done because there was no custody order in place at the time. This was later used against me as justification that I had no problem with him being unsupervised with the children, when in reality, I had no legal options. All I could do was try to come to an agreement with my abuser to get my children back safely. Later that night, he called 911 on himself and reported that he was having suicidal and filicidal thoughts, paranoia, and delusions involving cults and demons. Police responded and he was admitted into a psychiatric hospital. On October 18, 2023, while he was still at the psychiatric hospital, the courts granted an emergency order limiting him to supervised visits. The court recognized at the time that he posed a high risk to the children. After a 9-day stay in the hospital, he was released only because a family member agreed to take responsibility for him. The hospital did not believe that he was safe to be released on his own. Under the emergency order, he remained limited to supervised visits. But just a few weeks later, everything changed. At a November 7, 2023 hearing for temporary orders, Judge Valenzuela acknowledged the active order of protection. He acknowledged that he had been hospitalized for a psychiatric break. He acknowledged he had experienced suicidal and filicidal ideation. The danger was fully known to the court. Despite this, the court required no records from him to confirm his version of events. No hospital records, no psychiatric notes, no police reports, no treatment of information, no evidence of stability, nothing. Because all medical and psychiatric documents were protected by HIPAA, I had no access to them at the time. Only he did. Yet the burden was placed entirely on me, even though I could not legally obtain this evidence without his permission. This created an impossible legal dilemma. The court required me to produce evidence that I was legally barred from obtaining, even if it had been available at the time. In his filings and testimony, he claimed only bipolar disorder, leaving out the critical detail of psychosis. He told the court that he was taking his medication. He provided no documentation to support either claim. The court accepted his statements without requiring verification. There was no police reports reviewed, as it wasn't yet available, and no medical records reviewed, as I couldn't obtain them. The court stated that there was no evidence that he ever placed the children at risk, even though he had been in active psychosis. He had removed the children from school without my knowledge and outside of their normal routine, had violated the order of protection, and had expressed suicidal and filicidal thoughts. He had been found by police while delusional and had been hospitalized for 9 days because of the danger he posed to himself and to the community. Despite all of this, the court denied my request for supervised parenting time to continue. The judge ordered unsupervised equal parenting time only 2 weeks after his 9-day psychiatric hospitalization for a manic episode with psychotic features. Let me repeat that. He went from a full hospitalization for psychiatric features to a full unsupervised equal parenting time in just 2 weeks. The psychiatric hospital itself refused to release him unless another adult agreed to take responsibility for him. Yet, Judge Valenzuela determined that this same man was safe to be unsupervised with Alec and Lydia. The court wrote that unsupervised parenting time would be safe as long as he was complied with his medications. But the court placed no requirement in the order to verify medication compliance. In fact, the judge also placed this burden on me, stating that if I wanted to know if he was taking his medication, then I could just ask him. Well, how could I ask him if I had an order of protection against him? The risk was not hypothetical. The day he was hospitalized, he drove the children while in active psychosis. Later that night, he admitted to police that he was having thoughts of harming himself and the children. Research on adverse childhood experiences confirms that exposure to a parent in active psychosis is harmful to children, even when no physical injury has occurred. After temporary orders were issued, I filed a motion for clarification. In response, the court ordered a psychological evaluation. It was completed on February 27, 2024. The evaluation documented bipolar 1 disorder, most recent episode manic and severe with psychotic features. It confirmed that during his hospitalization, he experienced paranoia, mania, delusional thinking, and religious preoccupation. The evaluator even warned that noncompliance with his medication was likely to have a detrimental effect on his functioning. The report recommended ongoing psychotherapy, medication management, and safety planning. It also identified a pattern of avoiding self-disclosure, minimizing symptoms, and presenting himself as more stable and more capable than he truly was. Every one of these findings was based entirely on his own disclosure. Because the evaluator did not speak with me, did not review my evidence, and had no access to the history of abuse. Even with that limited information, the evaluation still revealed a deeply concerning clinical profile and significant safety risks. In the spring of 2024, the court held a brief status conference to review the evaluation. After reading the results, the judge, Michael Valenzuela, stated that he saw no concerns. That he stated that unsupervised parenting time would remain in place. The court did not acknowledge the predictable and grave risk of a person who had recently experienced delusions, religious preoccupation, and filicidal and suicidal ideation. The court placed no requirement for medication compliance. The court placed no requirement for treatment compliance. The court ignored every single warning and safety risk. The court exercised its due diligence without exercising its duty of care. Across all major professional bodies in the United States, Supervised visitation is the standard safety measure following a psychiatric hospitalization